panel for today's press conference.
Ladies and gentlemen of the media, press statement for a partnership in national unity. The APNU rejects the ruling of the Speaker. APNU rejects the ruling of the Honorable Speaker of the National Assembly, Mr. Raphael Trotman, MP, on the issue of whether Mr. Clement Rowe, MP, has a right to speak as Minister of Home Affairs, despite the fact that a motion of no confidence was passed against him by the majority of the National Assembly, has not been in accord with the democratic National Assembly and the principles of natural justice. The Speaker's diktat was handed down without giving the majority opposition and the minority government an opportunity to make their contributions on the issue in a debate in the National Assembly. This unprecedented and undemocratic step in imposing his ruling on the members of the National Assembly through the media and television, without giving them a hearing in the National Assembly, does not bode well for the future conduct of the people's business in the National Assembly. The Speaker's ruling was premature and preempted the imminent decision of the Honorable Chief Justice Mr. Ian Champ in the matter of Attorney General versus David Granger and Raphael Trotman, Constitutional Motion number 94 of 2012, and the Committee of Privileges to which he had sent the matter. The APNU states categorically that the Speaker is not above the members of the National Assembly who have been democratically elected by the people of Guyana. The Speaker is not a judge in the National Assembly, but rather sits as an umpire in the adversarial nature of the interaction between the government and the opposition. The Speaker, unlike a judge of the High Court of Guyana, does not have any inherent jurisdiction, but is bound by the standing orders of the National Assembly and the Constitution, like all other members of Parliament. The Speaker's ruling. The Speaker's ruling can be impugned on its legal soundness and factual inaccuracies. The Speaker arrived at his ruling that Mr. Clement Rowe, MP, can speak in the National Assembly as both Minister and an elected Member of Parliament, on a mistaken belief that Chief Justice Champ had so ruled after invoking Article 171(1) of the Constitution in the aforementioned motion. On the contrary, the Lord Chief Justice Champ at pages 24 to 25 of the judgment had dilated on Article 171 of the Constitution in relation to Attorney General and in Nandalal's contention that it had to be read subject to Article 106(6) of the Constitution to determine whether a member of Parliament could bring a no confidence motion against an individual minister, the Constitution being silent on the matter. The Lord Chief Justice in the said judgment, in about 5 separate instances, spoke of the dichotomy between the right to speak as minister or elected member of the National Assembly, that there was no right to speak as minister, but a right to speak as elected member. On the question of whether an individual minister, like the Cabinet, must enjoy the confidence of the National Assembly to continue in office or be responsible to the National Assembly, the Speaker said that the Constitution is silent on the matter. However, Chief Justice Champ at page 26 in the aforementioned judgment on interpreting the Constitution said this, and I quote, "It will be a quantum leap to say that because the Constitution has adverted to the possibility of to be proposed in the National Assembly for debate." End of quote. He further said, and I quote, "Therefore, the exercise of the power of a member of the National Assembly to propose such a motion for debate is not constitutionally prohibited or restricted." End of quote. The APNU submits that a successful no confidence motion against an individual minister must, as in Article 106(6), lead inexorably to the resignation of the minister. The Speaker also fell into error by 1, equating the position of minister to that of the President. 2, ruling that because we are a hybrid executive presidency / Westminster Model Assembly, we cannot take the benefit of the concept of individual ministerial responsibility, but must nonetheless take the burden of allowing a minister in whom confidence has been lost to speak a feature of a strict Westminster model construct. 3. Ruling that standing order 47 Rule 10 must be read, use them generous with the provisions of that standing order. And 4. The standing order 113 had no application to the issue. This is the end of it.
Thank you very much. Now, as I've said, please, if you wish to raise a question, use the microphone, state your name and the agency you represent.
Sir, I'd like to know, in light of your harsh criticisms of the Speaker in the press statement, to what extent do you hope to challenge his continued role as Speaker, and by what means?
I'm not sure it's Mr. Carberry or myself.
To you, Mr. Williams.
Well, I don't think there's any issue in this statement but challenging the Speaker in the context. We're talking about in the context of the issue before the Parliament.
Right. So it's only confined to this matter?
That's what we're addressing.
Raghavar Prime News. The Speaker's ruling seems to be final. Do you plan on challenging this once you get to the House at the next sitting? And we heard about talks with the Alliance for Change, but I'm seeing a statement from the Alliance for Change that says that party supports the Speaker's ruling. How do you see both parties moving ahead on this issue, given your strong position?
Well, to take the latter question first, the APNU, as you know, has been with this issue, and we've had the support of the AFC all along, but it has been characterized in the Parliament by different varying positions over time. If you would recall, we had the first motion, and then the second motion was stopped in its tracks, and the matter sent to the Committee of Privileges. Well, it hasn't come up yet in the Committee of Privileges. And it was also stated that the matter would abide the resolution by the courts. Of course, the court has not resolved the matter, and in fact, the decision is imminent in the Chief Justice by the Chief. No, Mr. Granger's motion has yet to be debated. And we believe that an issue of this nature should come to the Parliament and be debated fully. You see, we can't have a ruling outside the Parliament on a matter that really is supposed to be dealt with in the Parliament. And it must be debated. Even if that is the Speaker's position, the Speaker should recognize or ought to recognize that we have a Parliament and we have procedures. And so we bound to expect or have a reasonable expectation that the matter should be allowed to be debated, and if it's up to the Speaker to make his ruling at the end of the day, depending on the position of the parties in Parliament. But the Speaker is like an umpire in the Parliament. So it's an adversarial system, and you have the government on one side and the opposition on the other side. And they make their arguments, and then at the end of the day, within the rules of the standing orders, a decision is arrived
So my first question, room for challenge, and does this also mean that you deliberate the motion you bring it back to the debate?
Well, I want to say, if I could, one, I think it would be fairer to say that the AFC the ruling of the Speaker. They didn't say they agree, and that is a difference. I could disagree with you with respect. You know, I mean, I'm not speaking for the AFC, but I thought that was an important distinction to make. But because you asked, I think Mr. Shabral asked, is this ruling final? Although somewhere in his 17 pages, which I think the press had privy to before the opposition members, which is, I think, unheard of. And I really would challenge you who like research to search to see if there's anywhere in the Westminster system that is quoted so extensively here that the press is given a decision before the elected members, or the elected members are given it outside of the House by way of email, which can be tampered with, which obviously cannot be a secure method. But in his ruling itself, at page 17, just above conclusion, the Honorable Speaker says this: as for the motion being in the Committee of Privilege, remember he sent it still remains there until members of the committee indicate their desire to recommence consideration of the issues. The issue in that motion, which as Basil has reminded us, has never been debated, is whether the House, having found no confidence motion in, passed successfully a no confidence motion in Mr. Rohi, which the court have upheld is constitutional, whether he should be allowed to speak. So the Speaker saying this is the final ruling. But then he goes on to say, well, look, the Committee of Privilege, which I sent the motion to, he doesn't say that here, until they're considered. So let us assume that it goes to the Committee of Privilege, and the Committee of Privilege comes to, and it's a committee of the House, so it will have to report to the House, and the report to the House is, we think that, what is the Speaker going to say? Because if his ruling is indeed final, why is he saying that it's still in there? You can't have your cake and eat it. You can't say it's final and at the same time say it's not final. But one of the things that we find very unusual, in addition to the very strong legal points Basil made, is the fact that there seems to be a convenient lapse of memory as to resolution, as to the ruling coming out of the Speaker in November. Because in this ruling that came by email, it says here at page 12, in support of my previous ruling given on the 8th of November 2012 on the right of the Honorable Minister to participate in the House, he speaks about that ruling, but he doesn't go on to say that in that ruling he said, I find that in the absence of a resolution of the August House that specifically sanctions the minister and directs that he be restrained from speaking in any one or more capacities, I am by law duty bound to rule. So he's saying, look, the no confidence motion alone, that's what he ruled in November, the no confidence motion alone cannot, in my view, and having gotten the view of Mr. McKay and Mr. Stephen Fraser, cannot, in my view, and that's what he ruled in November, prevent the minister from speaking. You have to bring a specific resolution that specifically sanctions the minister and directs that he be restrained. That's at number 7 of the ruling of the 8th of November. And he goes on to say the last thing, consequent to my ruling, members of the House may wish to consider whether a substantive motion on the subject of the honorable member's participation in the House should be pursued or not. Subsequent to that, motion was pursued. It was moved by Mr. Granger, and because many seconded by Mr. Ramjitan. So this was a joint motion of the opposition, and that motion found its way on the notice and subsequent order paper because the Speaker himself ruled that it was in order. And now the Speaker turns around and rules without revoking his other ruling, because this ruling, this ruling dated the 8th, he referred to, is still extant. But it conflicts to an extent with this ruling here. But he hasn't sought to revoke his ruling, say, I was wrong on this day. So we have his ruling of the 8th of November, which says, bring a substantive motion. That was brought, it was passed, it could not reach on the order paper unless the Speaker found it was in order. He takes no responsibility for this, but he seeks at the penultimate page to say Mr. Granger motions unconstitutional, etc., without any reference to his ruling, which is still extant. So, and then he goes on to say, to confuse us even more, the Committee of Privilege could still deal with the matter whenever they decide. But my ruling is final. So in addition to all the points that Basil said, I will await the ruling of the Chief Justice. So we don't know. Another ruling may come. We don't know. We don't know.
So, Mr. Willis, Mr. Backer, what next do you intend to do in Parliament, in the National Assembly?
No, but I think we had the first part of the question from Ms. Rodriguez. Does that satisfy you, Ms. Rodriguez? That your question was addressed?
To an extent, but if Mr. Chabal seeks for the clarification,
Yes, I really would like to know what next do you plan to do in the National Assembly should Mr. Rui be given an opportunity to speak?
Oh, well, we firmly believe that this matter must come up in the National Assembly for debate. And if the Speaker then desires to make the ruling that he has sent out, then he can feel free to do that. But we should be allowed to debate this issue in Parliament because the issue has always been in Parliament. So it is not for the Speaker to stay in his chambers and send out this direction to us. It's a matter that must be debated and go through the processes in Parliament, and then the ruling could come.
But in light of the, all right, can I then ask you specifically, if it goes to debate and it has to go to, it could possibly go to a vote. Can it possibly go to a vote?
Yes, but that's a democratic process.
All right, because I'm now trying to think ahead to find out how would you then deal with the situation if the PEP, if the AFC votes along with the PEP.
I said they're free to do that, but what we're saying, the arguments in the Parliament, the debate would be on the Hansard. It would be in the Hansard, so it would be there for people to see.
So if your position is defeated, then you live by it.
Well, we don't have a majority in the Parliament by ourselves, so those things are not without our contemplation. But it's important for the Guyanese people to understand that we have a process, it's a democratic process, and the people we represent are entitled to have their voices heard through us.
Perhaps my final question, I hate to see that.
Excuse me. I think we already
Oh, there is a question, sorry. There was a body of opinion, ladies and gentlemen, that the Rohini Gag matter is occupying too much of space at this point in time, and there are other pressing matters that the National Assembly should address. And in so doing, the opposition, mainly the APNU at this stage, is wasting a lot of time. How do you react to those who think that way?
Well, we don't necessarily agree with that view. The work, we're carrying on the work in the Parliament, and we're carrying on with our business. You know, so this is not a matter that comes up every session. This is a matter that stretches over time.
You know, I always tell people the visible work of Parliament is on the floor. But Parliament is like, if I could draw an analogy, like an iceberg. The majority of work is done in committees. And Mr. Williams is chairing the local government committee, and he can tell you that alone, that meets more often than the National Assembly. Then we have, all those standing committees that you would be aware of.
You have a ticket issue.
You have the corporal punishment, you have the parliamentary management committee, we have the committee on appointments, a UG council. So a lot of things are going on, and you would remember that when the House was prematurely brought to an end on the last date, which was I think on Valentine's Day, actually the debate was we were in the middle of a debate on a bill brought by Mr. Greenwich. Yes. And I think the only criticism that could be made about Mr. Greenwich is perhaps he's working too hard, in that he's always bringing things to the National Assembly, and he's just one member of the opposition. So we're doing a lot of work. And I always throw this out to the thing. When you go and you meet with Dr. Luncheon, it may not be a bad, I'm trying to use it, but it may not necessarily be a bad idea to ask him if they want to move them. Has the government contemplated contemplated asking Minister Rohi to step aside or to reassign him, as is done throughout the world, to a different portfolio. Has the government thought of that as a viable option? We think it's a viable option.
Just expanding on what Dennis had talked a little bit about, if the opposition refuses to hear what Rohi has to say and they stage another walkout or they leave and it just comes down to voting, then him standing up as in capacity as minister means nothing because he won't be able to present any bills. What do you have to say about that? Like, where do you go from there if nothing comes through him that he wants to get done as Minister of Home Affairs?
If nothing comes to whom?
If he's not allowed to present any of his bills or anything at the National Assembly and you refuse to hear him, it just continues on like that.
Well, no, I think the government has the option to replace him with another minister. He still remains, he could be given another portfolio. The fact of the matter is that it is the considered view of the Partnership for National Unity that he has failed miserably in that office. You seem to forget that this whole issue has been precipitated by the killings of these people in Linden on the bridge. I don't know why we're losing sight of these issues. There have been massacres under his watch. Anything possible you could think about that is bad has happened on his watch. The Lusignan massacre, the Basico massacre, Lindo, I mean, do we need to go through this litany? But I wouldn't want to believe that Guyanese have short memory. I'm sure the families of the people would.
Okay, and then in the APNU statement where when you said that the speaker also fell in error by equating the position of the minister to that of the president, going through his ruling, when you look into it, it talks about the collective responsibility. So then is the opposition willing to make a no confidence motion against the president himself or against the actual government and not so much just at a minister level?
No, I think what is happening, that's why we're saying that it is not a correct statement. That the question about the minister in the context in which we're speaking is one where you have, if you look at the second limit of our contention, that Article 172, one doesn't apply to what he was contending. 171(1) of the Constitution. So if you follow the statement that you referred to, you will see that we're saying that it was a mistaken belief that the Chief Justice shall not so rule that as both minister and an elected member of parliament, the Speaker repeats his ruling that Mr. Clement Rohi can speak in the National Assembly as both minister and elected member of parliament on a mistaken belief that Chief Justice shall not so rule after invoking Article 171. Chief Justice shall never touch Article 171.
I got one more question. I don't know if you're aware of Ramparam, the Repairing Guyana's Broken System of Government, where he essentially goes through that the executive president has too much power, and if fresh elections are to happen, is APNU, or the APNU, sorry, are you willing to actually have meaningful engagement or a coalition government?
We campaign on shared governance. We campaign, it was one of our pillars, and we're still committed to shared governance. And that will be one of the reasons, and it goes back, listen, Mr. Granger didn't get up one morning and say, I will move a no confidence motion, Mr. Rohi. Mr. Granger, after measured consideration, after being approached by hundreds and thousands of Guyanese, and being very well versed in security issues, having been intimately involved, came to the opinion, and they said it is shared by thousands of Guyanese, that Mr. Clement Rohi, in his capacity as Minister of Home Affairs, he fell well short, way short of the minimum standard required of a minister. And that's why the no confidence motion was passed and supported by the AFC. It was supported by the AFC. It's not a witch hunt. It's not we don't like Mr. Rohi. We're saying Mr. Rohi has not performed as Minister of Home Affairs. And that is why it was brought. And we are committed. Our going after, as people say, going after Rohi, or moving a no confidence motion, Mr. Rohi, must not be equated to moving a no confidence motion in the entire government. We've not done that. We have the power to do that. We may not win, but we have the power. It may not pass the, may not get the vote. But that is not in our contemplation. If it was in, we would do it. Our position is that Mr. Rohi's ministry is one of the most sacred ministries that a minister, a person can have. This deals with life and death. Life is the most sacred gift that anyone has. And we are saying that in the hands of Mr. Rohi, we cannot leave such a sacred duty because he has failed, and he has failed miserably. That is not in contradiction, or does not contradict our continued desire to engage with the government and with the AFC towards a system of shared governance. They're not in conflict, they're not inconsistent. And we continue to remain committed to our manifesto.
So who would APNU support?
No, that's not for us. We accept that is not for us. That is for His Excellency the President to do. But we are saying to you, sir, the majority of people, because the AFC is saying the same thing, have no confidence in this minister. It will be presumptuous of us. Although people always say that APNU is presumptuous, there's a dictatorship of one, not that. It is not for us to say to His Excellency President who he was put. But we have the power to say, we have no confidence in who you have put.
So, Ms. Backer, again,
Sorry.
Pleasure News Update. On the topic of confidence, are you at this point confident in the Speaker's ability to lead the House? Yes or no?
I don't think the issue came up. I don't think that issue came up.
I'm not sure that anyone was questioning the competence of the Speaker. What they are questioning is the ruling of the Speaker.
but you said here clearly in your statement.
Could you
Hold on, that is.
Use the mic.
Could you please use the mic?
But you said here clearly in your statement in the third paragraph, this unprecedented and undemocratic step in imposing his ruling on the members of the National Assembly through the media and television without giving them a hearing in the National Assembly does not bode well for the future conduct of the people's business in the National Assembly. So in that respect, I think the question is really stands, do you have confidence in the Speaker?
Well, I don't think I don't know if we could make a generalization on an isolated incident. We're saying on this particular instance.
But you were saying the future conduct, sir.
We're saying on this particular instance, the Speaker opted to make a ruling on a matter of this nature outside without us giving us a chance to be heard in the chamber. That's where Parliament is. That's where the people's business is conducted. And so we expect that the matter would be debated in the Parliament, and then the Speaker, the parties on either side will make their determination on the matter.
And Ms. Batten, now, if the matter is debated and so on, where does this leave your determined position that Mr. Roy should go?
My determined, I don't understand.
Your position that you're determined that Mr. Roy must go. Where would the process leave you? Would it leave you in the cold?
Me, Debbie Backer, or me, APNU?
You, APNU, Debbie Backer.
No. I have never expressed any personal opinion about the
organizational opinion then, Ms. Backer.
Oh, the organizational position. Well, we will have, as Mr. Williams said, this is an unfolding matter. We remain resolute that Mr. Rohi is incompetent to perform as the minister, and we will continue to explore every legitimate means every legitimate means of having him not continue to be responsible for this very critical post.
Ladies and gentlemen of the media, I discern that you have exhausted your questions, and therefore let me thank you very much for coming to this press conference. I am encouraged by the fact that the female fraternity in the media has turned out in such great force today, and I sincerely hope that this is a trend for the future, and I would see more of the female fraternity at these press conferences. Thank you very much, and I look forward to seeing you at our next press conference.